Hello everyone, and welcome to Taylor Wessing's latest data protection webinar. This is part of our data protection webinar program where we bring you our expertise and views on topical data protection issues. Regular attendees are going to be very familiar with the wide range of topics that we've tracked over the years, including obviously more recently the core requirements and practical applications of the GDPR. But there's also been sessions where we've looked at the data protection considerations for particular areas or focus topics such as cybersecurity or direct marketing, or where we've focused on perhaps more different or challenging or disruptive technologies such as connected devices and big data. Today, however, we're looking at Brexit and what that means for data protection. Now, while we may all be heartily sick of hearing about Brexit, there are clearly some very important data protection impacts that flow from Brexit that we need to be aware of, plan for, and action. For those of you who are new to Taylor Wessing or to our webinar program, welcome. By way of introduction, Taylor Wessing is a leading international law firm acting for a range of clients in local and international markets, providing a full-service offering from our office footprint that you see here spans across Northern, Central and Eastern Europe, the Middle East and Asia, along with our US representative offices. This webinar is brought to you by Taylor Wessing's International Data Protection Practice, and we're a global 22 partner-driven team, also complemented by our broader international network of data privacy law specialists. We also have a dedicated microsite for all things data protection, our global data hub. You can learn more about both our practice and access compliance news and resources and tools from our global data hub site, which includes things like news and weekly updates with a bi-monthly mail shot if you register, topical issues where we'll look regularly at issues that are raising concerns such as Brexit today, and details of our forthcoming webinars along with recordings of our archived webinars. The Global Data Hub is also where you can access checklists and tools. For example, we have our Global Data Protection Guide, which allows you to compare national data protection laws of more than 60 countries. And then there's also our TW Cyber Response app, which has been developed to help companies prepare for, react to, and respond quickly and effectively should a breach occur. My name is Sally Annero, and I'm a senior member of the London Data Protection Practice. And today's webinar includes a number of different team members from that practice. To start, my colleague Debbie Hayward, and she's going to be looking at how the absence of a deal or the absence of an adequate decision at the end of a negotiated transition might affect data protection. And then following Debbie, Nikita Saini is going to be looking at the pros and cons of different export solutions. Then my colleague Mary Rendell will be considering how Brexit affects the obligations relevant to designating a lead supervisory authority and the location of your DPO. And then Anjali Chandarana will be looking at the role of the representative and its importance in the context of Brexit. Last but very much not least, we're also very fortunate to have with us today a surprise external guest, Mr. Andrew Elliott. Andrew is the Deputy Director for EU Exit Readiness at the Department for Digital Culture, Media and Sport, or DCMS. And his team is working with businesses across the UK, helping them to understand how data protection law might change on the 29th of March this year. Prior to joining the EU Exit Readiness team, he previously led the team that put together the UK's Data Protection Act 2018. So I think you'll agree that he's very well placed to speak to DCMS's involvement and views on some of these very key questions around the data protection implications of Brexit, and we're very grateful to him for making the time at short notice to join us today. At the end, we're going to have our usual short selection of polling questions where you can get a view in the aggregate of the position of our fellow listeners today on some of the points of preparedness around Brexit. So without further ado, I will pass over to my colleague Debbie.
Thanks, Sally. Brexit. Oh no, I've lost the slides. Sorry. Well, what can I say? I mean, that probably sums it up. 4 weeks to go, and we still don't know whether we're going to leave the EU on the 29th of March and on what terms if we do. Will there be an extension of Article 50? Will there be a second referendum? Will Theresa May's deal go through, or will we exit on the 29th of March without a deal? I suspect even Andrew can't say for sure at this point, and the most likely outcome does seem to change on a daily basis. We all know business hates uncertainty, but I do have what I think are hopefully some words of comfort with respect to data protection. Actually, despite the uncertainties, this is one area where we do know quite a lot. And even in a no-deal scenario, this is a situation where businesses do have quite a high level of control, certainly compared with other areas. The good news is that businesses can, to a reasonable extent, take their own steps to minimise disruption. And the government has also done what it can to ease the process more successfully in the area of data protection than in many other areas. And I hope Andrew's going to take that as a compliment, but I'm sure he'll expand on that issue later in the webinar. Right from the start of the Brexit negotiations, I think it's fair to say that both the UK and the EU have placed considerable emphasis on ensuring data flows between the EU27 and the UK are not disrupted. And this really is more than just hype. We know this because of the high profile given to maintaining the free flow of personal data between the EU and the UK after Brexit in the political declaration on the future relationship. Now, whether or not the declaration survives in its current form, we don't know that yet, but the data protection aspects are relatively uncontentious, and I would expect them to be replicated in any future declaration. The political declaration stresses the UK's commitment to a high level of personal data protection. It says that the EU will aim to adopt an adequacy decision by the end of 2020, and in the same time frame, the UK will take comparable steps to facilitate personal data flows to the EU. In fact, it's already done that to a degree. We've known for some time that the EU would not begin adequacy decisions until after exit, but it's reassuring, or at least not officially, but it's reassuring to learn that the UK is unlikely to go to the back of the adequacy queue if and when negotiations do begin, and whether or not we exit with a deal and a transition period. Having said that, I do have a slight caveat, and it's probably worth mentioning that the European Data Protection Supervisor made some comments last week, which were somewhat more cautious, both about whether or not the UK would go to the back of the queue and whether and when it would achieve adequacy. So what will the UK data protection regime look like after Brexit? The UK's made preparations to adapt the GDPR to work as a piece of UK legislation in conjunction with the Data Protection Act 2018, the DPA. It's produced regulations which will come into force on exit day, although if there's a transition period, application of all except the part relating to PECA will be delayed. Now, these regulations consolidate and amend the EU GDPR and the UK DPA 18 to create a new UK GDPR. But in practical terms, the responsibilities of data controllers and data processors in the UK won't change. GDPR standards will continue to apply. There are changes, though. The ICO, for example, won't at the moment sit on the EDPB and won't participate in the GDPR consistency mechanism, and I'll talk more about that in a minute. The extraterritoriality of the UK's data protection framework will continue to apply. What does this mean? Well, controllers or processors based outside the UK processing personal data about individuals in the UK in connection with offering them goods or services or monitoring their behaviour will be caught. Crucially, this will include controllers and processors based in the EU. The impact of the UK sitting outside the EEA without a transitional deal on exit, which would preserve the current position, or an adequacy agreement, will be felt in a number of areas. The one everyone's focused on is the issue of data exports and imports. The default position, either if the UK leaves the EU without a deal or at the end of a transition period, is that it becomes a third country for the purposes of transfers of personal data from the EU. The EEA countries will similarly become third countries with regard to the UK. That means the UK will either need an adequacy decision or the EEA organisations will need to use one of the data transfer mechanisms to export EU data to the UK. As we know, under the GDPR, personal data can't be transferred outside the EEA unless there are protections in place to guarantee individuals equivalent rights and protections to those they enjoy in the EU. Those countries which are considered to have a data protection regime which provides an adequate level of protection equivalent to that in the EU may benefit from an adequacy decision which allows the free flow of personal data from the EU. Currently, we have 12 jurisdictions, including the Channel Islands, with full adequacy decisions. South Korea is currently being assessed, and the US has a partial and somewhat controversial adequacy decision in relation to transfers under the EU-US Privacy Shield. In the absence of an adequacy decision, a number of other data transfer mechanisms can be used, principally the EC's standard contractual clauses, or SCCs, or binding corporate rules, or BCRs, and Nikita is going to look at those in more detail shortly. So looking first at data exports from the UK to the EEA, this is the easy bit. Under the regulations, the UK government has done what it can to preserve the free flow of personal data from the UK to the EEA. The UK is intending transitionally to recognise all EEA states, the EU and EEA institutions, and Gibraltar as providing an adequate level of protection for personal data, allowing personal data to flow freely to them from the UK. Effectively, this preserves the status quo. What about data exports from the UK to third countries outside the EEA? Again, the regulations are providing reassurance in this area by essentially preserving the effect of existing mechanisms. This means that the effect of existing EU adequacy decisions on a transition will be preserved on a transitional basis, including the Privacy Shield. SCCs previously issued by the Commission will continue to be an effective basis for international data transfers from the UK in a no-deal scenario. So organisations which transfer personal data to organisations overseas on the basis of SCCs can continue to rely on them. The ICO will also have the power to issue new SCCs after exit day. Existing authorisations of binding corporate rules made by the ICO will continue to be recognised in domestic law, and the ICO will have power to authorise new BCRs after exit day, but there is an issue where BCRs have the ICO as their SA. Essentially, businesses will need to select a new SA in accordance with Article 29 Working Party guidelines, because the ICO won't, as far as we know, be part of the BCR community after exit. Onward transfers of data originating in the EEA could also be more problematic, as flow down of EEA protections will be required. Looking now at EEA to UK data transfers, this is more complex because UK businesses importing personal data from the EEA will need the exporters to take action in a no-deal scenario. The reason for this is that the UK just can't provide for the free flow of personal data into the UK. So these are the data flows most at risk in the event of a no-deal or no adequacy Brexit. If you rely on these types of transfers, you will need to make suitable provision, like entering into SCCs, and you should have these in place by the 29th of March. Obviously, it's unclear as to whether or not they'll be needed at that time, but at the least you should prepare to put them in place if you need to. Finally, what about data transfers from the UK to the US under the Privacy Shield? Well, the regulations again provide for the effect of the Privacy Shield to be preserved with respect to UK personal data flowing to the US. The US Department of Commerce has said that US businesses importing personal data from the UK will need to state that explicitly in their Privacy Shield statements, and they may also need to make the same point clear in HR privacy policies if they're importing HR data from the UK. And they've provided a set of Q&As designed to help ensure these transfers continue uninterrupted. In all the furore around cross-border flows, other data protection issues have tended to be seen as secondary, but they are still important. It's not just the exports and imports which are an issue. Businesses are also going to have to consider whether they have to appoint a representative in a third country jurisdiction. Under Article 27 of the GDPR, controllers and processors not established in the EU have to appoint a representative unless they're a public authority or their processing is only occasional, low risk and doesn't involve special category or criminal data on a large scale. With the UK outside the EU, businesses with establishments in the UK but not in the EU may be caught by Article 27. Similarly, the regulations, the UK regulations, replicate Article 27 so that controllers and processors not established in the UK, including those in the EU, will be required to appoint a representative, again, unless they're a public authority or the processing is only occasional, low risk and doesn't involve special category or criminal data. And Anjali will talk more about that in a minute. Mary is going to look at the impact of Brexit on the location of your Lead SA and DPO. One of the long heralded advantages of the GDPR compared with the outgoing EU data protection regime is the one-stop shop regulatory mechanisms for organisations processing personal data across the EU. But the UK will, as far as we know, no longer be able to participate in this after Brexit except during any transition period, which means that if you currently have your Lead SA in the UK, you will need to consider the location of a Lead SA in the EU 27. And you may also want to consider whether you need a DPO based in the EU. The next thing is to check your contracts. However you decide to handle the issue of Brexit, it's important to check that any existing contracts and terms and conditions match your intentions. And this is particularly true for data transfer agreements or data processing agreements. Don't forget that whatever the lawful basis you rely on to export and or import personal data, you may also need a data transfer agreement or a data processing agreement. For example, for data exports to a processor or sub-processor, the GDPR sets out detailed requirements that an agreement must include in addition to addressing the transfer. So, existing agreements, policies, terms and conditions may all need to be amended or replaced if, for example, you decide to change the location of your DPO or your Lead SA, or perhaps even the law under which the contract is governed to one in the EU. You will also need to ensure there's an appropriate provision made for initial and onward transfers in accordance with GDPR requirements, especially as the first transfer you make may no longer be the one originally envisaged in the relevant contract or terms and conditions. Finally, before I hand over, I want to mention some other resources that are available. We've published materials on all the topics we're discussing today on our Global Data Hub, and we've also produced a checklist for UK businesses, but you don't just need to take our word for it. The UK's ICO has published guidance for businesses and SMEs on preparing for a no-deal Brexit. This includes a six-step plan, a broader guidance, FAQs, and an interactive tool to help assess whether SCCs are an appropriate data transfer solution. Further guidance will be provided to organisations currently relying on BCRs, but as I mentioned, the EDPB has put out very brief guidance on that. As I'm sure Andrew will mention, the government has also published technical notices and advice, so there is quite a lot of support available. As I mentioned, depending on what happens in the next few weeks, it's very hard to know which of the issues I've discussed are going to be most pressing, if indeed any of them are, but it's also important to be prepared. And as I said at the start, there really is a lot which you can do in this area to smooth the process. And I'm going to hand you over to Nikita now, who will talk you through the pros and cons of the available data transfer solutions.
Thank you, Debbie. My name is Nikita Saini. I'm an associate in the data protection team, and I'm going to run through cross-border data flows and issues with regard to data transfer solutions available and highlight the pros and cons of these mechanisms. So why is this important? Well, just by way of a brief recap, the GDPR sets out that personal data can only be transferred beyond the EEA if it's subject to an adequate level of protection. And the GDPR itself also provides the reasoning behind this. So these transfer conditions are in place to ensure that the protections that the GDPR gives to individuals isn't undermined as part of this process. So why have data transfers suddenly taken center stage? Well, personal data can flow freely within the EEA and from the EEA to countries with an adequacy decision. So this is a decision that's adopted by the European Commission, and it formally establishes that a non-EU country ensures an adequate level of protection of personal data. Now, just to recap what Debbie mentioned earlier, when the UK leaves the EU, we'll no longer be a member state, but for all intents and purposes, will be considered a third country. So if an adequacy decision is granted to the UK as part of a Brexit plan, this will allow for the free flow of data between the UK and the EEA. But in the absence of an adequacy decision, the EEA and UK organisations that are sharing data across borders will need to ensure that appropriate protections are in place to allow for that transfer of data in a cross-border situation. So this might mean implementing data transfer solutions which weren't required before Brexit. Now, the UK has confirmed it will preserve existing adequacy decisions on a transitional basis, and in doing so is going to recognise certain countries as providing an adequate level of protection of personal data. So there'll be no restrictions on data being exported from the UK to the following countries: Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, the Isle of Man, Jersey, New Zealand, Uruguay, and Japan. Likewise, the UK is also going to recognise all EEA states, EU EEA institutions, and Gibraltar as providing an adequate level of protection of personal data. So similarly, there won't be any restrictions on data that's being exported from the UK to these regions. Moving on to Privacy Shield. This is a data transfer mechanism that allows data to be transferred from the EU to the USA safely. The UK has also confirmed that this solution is going to be preserved post-Brexit, which means that data flows between the US and the UK can continue, and this applies to both imports and exports. So what are the advantages of Privacy Shield? Well, you can self-certify on the Privacy Shield website. It's very quick for an organisation to do this. Registration's inexpensive, it's fairly straightforward. There's no need to sign individual contracts for each particular transfer that you want to undertake. So one certification will cover an organisation for its UK data imports and exports. It's not available for all businesses though, so it's only available to those who are regulated by the FTC or the DOT, and it's not open to financial services providers either. There's also a requirement that an organisation will need to engage directly with EU and UK regulators if they're handling HR data. One of the requirements that an organisation also needs to keep in mind is that you need to reply to complaints within 45 days and display a privacy statement on your website. Just as a cautionary note, transfers of UK data, when you're relying on the Privacy Shield in order to do this, it can only take place post-Brexit if an organisation's updated their privacy statement and relevant HR policies to explicitly refer to UK transfers. So for an organisation, what does this mean? It means taking a look at your policies carefully and ensuring that they're compliant for a post-Brexit scenario. As a cautionary note, Privacy Shield is still valid, but EU regulators continue to have concerns, just following on from the safe harbour regime being declared invalid. It's past its second annual review, so it's still a perfectly mechanism for now. Moving on to standard contractual clauses. These are also known as model clauses. So what are these? These are sets of clauses that are prescribed by the European Commission, and they can be used for data transfers. They're probably going to be the most suitable solution for data imports, so data coming into the UK from the EEA post-Brexit, and also for data exports, so from the UK to third countries. It's standard wording. This is available free of charge from the European Commission website, so it's a low-cost mechanism, and it also provides certainty because there are a standard set of clauses that are coming from the European Commission. They're quick to obtain and they're pretty easy to use and implement into your contracts. And that's one of the main advantages of this particular mechanism. You can integrate them fairly quickly into your commercial agreements, particularly if you're thinking about intergroup agreements and you want to allow for data sharing within companies or cross entities within a particular group. However, some of the points to note in relation to model clauses, they are quite limited when it comes to flexibility, so they're not effective if they're going to be altered. And as another note, standard contractual clauses are only going to cover the data description. So an organisation will need to undertake a certain amount of tailoring in order to rely on these. So the description of processing schedule will need to actually cover the data description. So you'll need to set out the processing that you want this to cover. If it's not set out, then it might not be protected by these particular clauses. The good news is these can be used between controllers, so they can be used from one controller to another, they can be used between controllers and processors, but they can't be used between processors, so they're not available to all organizations and in all contexts. Finally, moving on to binding corporate rules, or BCRs. What are these? These allow for personal data to be transferred by multinational companies within a group from the EEA to affiliates outside the EEA. The ICO states that they're going to recognise BCRs that have been entered into before Brexit. And Article 48 of the GDPR sets out what this entails. Essentially, BCRs means personal data policies. They operate like a set of conduct rules internally, so they allow for data to be transferred internationally within the same group to countries that don't offer an adequate level of protection of personal data, to countries that don't have an adequacy decision. The main advantage of this is that BCRs provide a single solution. So again, like with standard contractual clauses, you don't need multiple contracts in order to undertake data transfer in a cross-border scenario. And these apply to controllers and processors, both importers and exporters within the group. And they can be tailored to the business. They can be tailored to reflect your group structure and what your activities are. There's flexibility to accommodate changes in the group structure itself and to account for your data flows, provided that this doesn't go beyond the scope of the BCRs themselves. A key point to note with BCRs is that they need to be pre-approved by a lead EU regulator. How they work is that you have one supervisory authority that will take the lead and will liaise with other supervisory authorities in regions where entities are present that you want to transfer personal data. So this means that clearance is going to be required from each supervisory authority. So potentially one of the points to note with this is that they can be a really lengthy process potentially. You'll also need to obtain fresh clearance if the group structure goes beyond the scope of BCRs. So that might take further time to obtain that clearance, and it could add to what's already an existing kind of lengthy process. Another point to note is that applicants need to demonstrate that their BCRs are subject to adequate safeguards of protecting personal data throughout the group. So what does this mean? It means an organisation needs a detailed compliance plan that underpins these BCRs. So this will involve audits, training, regularly looking at what you're doing in terms of personal data and how you're handling this as a prerequisite, which needs to underpin your BCRs. So it kind of works on the basis that there's a strong foundation when it comes to GDPR compliance in the first instance in order for these to be approved. In recent news, Debbie briefly touched on this, but I'll summarise this for the purposes of this slide. The European Data Protection Board confirmed that the ICO will not have a role in the BCR community post-Brexit. So what's the impact of this? Groups that are headquartered in the UK that want to apply for BCRs will need to identify the most appropriate BCR lead. This will need to be a supervisory authority in an EU member state, not the UK. For existing applications, so for those organisations that are at the review stage, they'll also need to identify the new lead supervisory authority, and that regulator will need to formally take over the application and initiate a new procedure in the event of a no-deal Brexit taking place. If organisations at the draft stage, so a draft been submitted, if an ICO decision is pending at the time of a no-deal Brexit, they'll need to identify the new lead who will need to take over and resubmit the application. And for authorised holders, they'll need to identify the new lead. The EDPB directs to a particular criteria. It's the Working Party 263 criteria for assistance with identifying your new lead and the relevant criteria that an organisation will need to look at when it comes to binding corporate rules in the context of Brexit, and this is available online. I'm now going to hand over to my colleague Mary, who's going to talk about the impact of Brexit on the location of lead supervisory authority and DPO.
Thank you very much, Nikita, and hello everyone. as Nikita mentioned, I will be talking about the impact of Brexit on the location of the Lead SA and the DPO. So just to start with a bit of background, one of the aims of the GDPR was to reduce the regulatory burden on organisations that carry out processing in more than one EU member state. The GDPR introduced the principle of the one-stop shop, which allows organisations whose processing of personal data substantially affects or is likely to substantially affect data subjects in more than one member state to nominate a lead supervisory authority in the member state of their main establishment. Having a lead SA may mean that you only need to deal with a single regulator. However, national supervisory authorities do remain competent to deal with complaints that are directed to them or if there is an infringement within their country affecting data subjects there. Now, just to go back to what main establishment means, this is a fairly complex idea and it will often be the place of your central administration, but it also has to be an establishment that has real decision-making powers in relation to that business's data processing operations. This definition means that there will be a lot of organisations that may not actually have a main establishment in the EU. For example, if your head office is in the UK, and there aren't many people currently on the ground in the EU, but you are carrying out cross-border processing, once the UK leaves the EU, you may not have a main establishment within the EU. There will also, of course, always be some borderline cases, and you may wish to engage with the relevant supervisory authorities in the member states where you have establishments. To make things a little bit more complicated, there are some establishments that have real decision-making powers in relation to different processing operations, opening up the possibility of having more than one lead SA for one business. So coming back to Brexit, what will the impact of Brexit be on the supervisory authority in the UK, which is obviously the ICO? Now, when the UK leaves the EU, the ICO will no longer be a supervisory authority for GDPR purposes, and so the ICO will not be able to participate in the one-stop shop mechanism. When the ICO is no longer a supervisory authority, it will lose its power to be nominated as a lead supervisory authority, and as Nikita mentioned, it will also lose its power to approve binding corporate rules. So what does this mean for the businesses that currently have their main establishment in the UK and view the ICO as their lead supervisory authority? For example, say a UK company has its headquarters in the UK, but it also has a distributor in Germany and shops across the EU. This business will need to evaluate its processing operations and decide whether, once the UK is no longer in the EU, whether there is still a main establishment within the EU. This means looking at where the place of central administration in the EU will be post-Brexit, and whether the German distributor establishment or any of the other establishments in the other member states, have the real decision-making powers necessary in relation to the processing operations of that UK headquartered business. If it was decided that the German establishment, for example, does have those real decision-making powers in relation to the processing operations, then the organisation could nominate the German supervisory authority as its lead supervisory authority. However, if none of the establishments across the EU for this UK headquartered business have any real decision-making powers, and actually all the decisions about the processing operations are very much still made in the UK, then none of the EU supervisory authorities could be nominated as the lead SA for that business. And in that example, it means that all of the supervisory authorities across the EU would be competent to look at that business's processing operations. Now, just to flag that post-Brexit and currently as well, that businesses without a main establishment in the EU will need to appoint a representative within the EU, and I think Anjali is going to discuss that in further detail. So, choosing a new lead SA post-Brexit. Some businesses that are considering the issue of where their new lead supervisory authority will be might be thinking of choosing a supervisory authority that is closely aligned to the UK and the ICO. And some may feel that the obvious choice with this might be Ireland, particularly because they speak the same language as the ICO. However, it is very clear that forum shopping is not allowed under the GDPR and in relation to the one-stop shop principle. This point was particularly demonstrated in the recent decision of the French supervisory authority, the CNIL, in its decision in relation to Google. Now, just to recap on the facts of this decision, Google had claimed that its main establishment within the EU was its Irish business, its Irish establishment, and so had therefore nominated the Irish Supervisory Authority as its lead SA for Google's cross-border processing in the EU. The CNIL challenged this nomination and said that Google's Irish establishment did not have the real decision-making powers necessary, and so the Irish authority could not in fact be its lead supervisory authority for certain processing activities. Therefore, the CNIL decided that it in fact had jurisdiction to investigate Google's processing operations. Now, this decision really highlights that there must be those real decision making happening in the country where you state that your main establishment is based, because otherwise another supervisory authority, as shown by the CNIL, can challenge your lead SA nomination. So this leads on to the question of the effect of Brexit on businesses that carry out cross-border processing throughout the EU and currently have a UK-based data protection officer. Now, the GDPR does not actually state where a DPO must be located. Instead, it simply says that the DPO must be easily accessible from each establishment of that organisation, so that employees, data subjects and the supervisory authorities in countries where the organisation is based can contact the DPO easily. It could be argued that with the UK being geographically very close to Europe, that even after Brexit, a UK-based DPO would still be easily accessible from the EU countries. However, the Article 29 Working Party guidance on DPOs states that they recommend a DPO is based in the EU unless the organisation doesn't have an establishment there. This guidance was published in 2017 when the Article 29 Working Party knew that Brexit was on the horizon. However, this guidance is not binding and it has not yet been tested by the courts, so we will wait to see what happens there. One point to note from the recent Google CNIL decision was that the absence of a DPO in Ireland was seen as relevant when determining whether Google Ireland was not, in fact, Google's main establishment in the EU, so I just wanted to flag that. And finally, just a reminder that if you do decide to move the location of your DPO, you will need to give the new details of your DPO's location to the supervisory authorities in the countries where you have establishments. I will pass over to Anjali, who's going to talk about representatives.
Thanks, Mary. So my name is Anjali Chandarana, and I'll be talking about when and how to appoint a GDPR representative. So I'm sure you know one of the novelties of the EU's data protection regime is its territorial scope under Article 3. So the GDPR explicitly applies to certain data processing operations, even though the controller or processor may not have any presence in the EU. And it's generally a challenge for regulators to enforce the GDPR against a business without an EU presence. And so the GDPR has sought to deal with this challenge by introducing a requirement for non-EU organisations, which are caught by the GDPR, to appoint a representative. So there are a number of points to consider when appointing a representative, and the first key question is what actually is a representative and when do you need one? So a representative is a natural or legal person appointed to represent controllers or processors that are not established in the EU. So that would be those businesses that don't have branch, representative, office or other unincorporated presence in the EU. So the obligation to actually designate a representative is applicable to any controller or processor which, as mentioned, doesn't have an establishment in the EU and which processes the personal data of data subjects in the EU relating to offering goods or services or monitoring their behaviour there. So there are exceptions to that requirement, and that's where the entity is a public authority or body, or the data processing in question is only occasional, presents a low risk to data protection rights of individuals, and doesn't involve special category or criminal offence data on a large scale. So the second question is who actually can be a representative. So as I mentioned, a representative may be a natural or a legal person. ICO guidance and draft European Data Protection Board guidance on territorial scope suggests that representatives can include law firms, consultancies and other private companies as long as they're actually established in the EU. And another important point to note is that one representative can actually act on behalf of several non-EU controllers and processors. And another key point to be aware of is that a representative should not be an external data protection officer. So guidance suggests that the roles are actually incompatible and combining them would run the risk of a conflict of interest. So the third question is, how do you actually appoint a representative? So the appointment of the representative must be in writing and it should clearly set out the terms of the relationship, including details of the representative's obligations. And guidance from the ICO recommend that using a simple service contract is fine, and it's important to note that even though there is a service contract in place, that representative, the appointment of that representative will not mean that there's an establishment. Draft guidance also suggests that it's good practice to locate the representative in a member state in which a significant proportion of data subjects whose personal data are processed. Regardless of that, the representative must remain easily accessible to data subjects located in all the relevant member states, and the help of a team, if necessary, must be able to communicate in the languages of the relevant data subjects and relevant supervisory authorities. It's also important to note that if a company or any other type of organisation is appointed as a representative, a single individual should be assigned as a lead contact and person in charge for each controller or processor representative. So going on to what actually is the representative's role and implications. So the representative must act on behalf of the controller or processor it represents with regard to that controller or processor's obligations under the GDPR. In particular, it must perform its tasks according to the written agreement with the controller or processor, and that includes cooperating with the competent supervisory authorities which may contact them in relation to any compliance matter. Secondly, they must facilitate communication between data subjects and the controller or processor they represent, in order to make sure the exercise of data subjects' rights are effective, although it's important to note that representatives are not actually required to give effect to those rights themselves. And thirdly, they should also maintain a record of processing activities in accordance with Article 30 of the GDPR. Interestingly, guidance suggests that the maintenance of this record is a joint obligation and that the appointing controller or processor must provide its representative with all accurate information so that that record can actually be maintained and made available by the representative. So there are also a number of implications to consider in relation to the designation of a representative, and I'll just talk briefly about liability and also information requirements. So it's important to note that the designation of a representative doesn't actually affect the responsibility or liability of the appointing controller or processor under the GDPR. But enforcers are actually able to initiate enforcement action against the representative in the same way as it would against controllers or processors, and this includes the possibility of imposing fines, penalties and holding representatives liable. And it's unsurprising that regulators can hold representatives liable for their own non-compliance with their GDPR obligations. What's more surprising is the suggestion in recent guidance that representatives might be liable for the actions or inactions of the organisations which they actually represent. And because of that, it may actually become hard to find someone willing to take on the role of a representative. And hopefully there'll be sort of greater clarity on this issue once the European Data Protection Board guidance is finalised. Just going on to information requirements. So information about the representative should be provided to data subjects, for example in your privacy notice, or provided to data subjects at the moment of data collection. It should also be made easily accessible to supervisory authorities, for example by publishing it on your website. There is no obligation to actually directly notify supervisory authorities. So just in terms of next steps for your business and whether will you have to appoint a representative after Brexit. So as Debbie touched on earlier, after the UK exits the EU, the GDPR will require that a controller or processor located outside of the UK, but which must still comply with the UK GDPR, will be required to appoint a UK representative unless one of the exceptions that I mentioned earlier applies. And if you are based in the UK and not established in the EU, but are either offering goods or services to individuals in the EEA or monitoring the behaviour of individuals located in the EEA, then you'll still need to comply with the GDPR regarding that processing even after the UK leaves the EU, and also may need to appoint a representative in the EU. And then additional steps to consider are, if you do need to appoint a representative in the EU, considering where they should be based, and as mentioned, putting in place an appropriate service contract for that representative acting on your behalf. I'll now pass over to Andrew Elliott.
Thanks very much, Anjali. So, as I mentioned at the beginning of the webinar, we are very lucky today to have with us Andrew Elliott, who is the Deputy Director of EU Exit Readiness, and in a previous existence also marshalled the Data Protection Bill into a Data Protection Act in the UK. And I think it's very helpful that he's able to join us. Perhaps we can pull together some of those strands that we've been looking at in the session today, where we've looked at adequacy and how it's achieved. In a Brexit scenario, the pros and cons of different export solutions, how Brexit affects lead supervisory authorities and location and appointment of DPO, and the roles of representatives. So just to perhaps set the scene first, Andrew, I think it would be very helpful for the audience just perhaps to understand the role of the DCMS in respect to data protection and Brexit.
Sure, and thank you very much for inviting me along today. It's very helpful to be able to talk to businesses in fora like this. And it's actually quite reassuring that the presentations which have been given, really, I think we can fully support. They're precisely the messages that we think that businesses ought to be receiving. So DCMS is the UK government department which is responsible for data protection amongst many other things. We are the department who took the GDPR and implemented it into our legal system last year. We repealed the Data Protection Act 1998 and replaced it with the new Act last year. We're also the department who has, in the current context, prepared the statutory instrument which has recently completed its passage through Parliament to amend our law in the event of no deal on the 29th of March. And our current focus really is on trying to prepare businesses for that outcome. Our technical notices that we have published seek to do that, but we also have teams who are going around talking to businesses and trade organisations all around the United Kingdom to try to help people get ready. Of course, we hope that we won't have a no-deal situation, and DCMS is also working to prepare ourselves to negotiate for a successful and quick adequacy decision as soon as we can, deal or no deal.
That's, I think, a very relevant point, because if we do go into transition, so when there's a negotiated transition, is it likely that we would get an adequacy decision before the end of transition? Or alternatively, if there's no deal, how long might it be likely to be before the UK could get an adequacy finding, do you think?
Well, it's very difficult to give an absolutely clear cast-iron answer to that question. In the event of a deal, we are confident that we should be able to secure an adequacy decision during that window taking us up to December 2020. And we've had discussions with the European Commission as to whether or not that's a realistic objective, and we all have a shared view that should be achievable. In the event of no deal, you would hope that it wouldn't take longer to negotiate, but we are starting perhaps from a slightly different position without a deal. We haven't got the agreement in place to do it quickly. We'd hope that there was goodwill and that we were able to negotiate this as fast as we can. We could look to the example of other countries. I think the sort of ballpark period as these things take, perhaps up to 2 years. But I think that the message I need to give to businesses is that in the event of no deal, you cannot assume that there will be an adequacy decision quickly. It would be extremely risky to choose to do nothing and to hope for a quick adequacy decision. You need to act to secure your data flow, and that essentially means putting in place standard contractual clauses in the absence of binding corporate rules.
Thank you very much. Just looking at some of the questions that have been coming through, there's one particular question that has come through at least 6 times, which is, to paraphrase, because it has come in a number of different guises, but in essence, what do businesses need to do to safeguard flows of personal data from EU processors to UK controllers? Because obviously standard contractual clauses are not kind of available to anticipate that scenario. So what's the situation there?
Yes, I have noticed that question coming up more and more and more, and it's been extraordinary watching it appear across the screen here, repeatedly from people watching today. And actually, I kind of find it reassuring that we are asked this more and more and more, because it suggests that as we get close to 29th of March, people really are looking at their data flows and working out what to do, and are recognising that they do have this particular data flow, no doubt amongst many others, where there is no standard contractual clause. So it is not entirely straightforward. We do not know for sure whether or not this is a restricted transfer between an EU processor and a UK controller. You have to remember that the GDPR is a relatively young piece of legislation, and it hasn't really been fully tested in many ways, this amongst other areas. So the European Commission has not provided a mechanism to allow you to put in place standard contractual clauses. As we heard earlier, if you want to put in place standard contractual clauses, you can't just go and make them up yourself. You have to put in the actual text that has been provided. And there isn't one available here. So I think that the best advice is to make sure that you have spoken to your counterpart, who is processing your data in Europe, that you have clocked and you have identified that data flow, and that you stay alert for advice, because the European Data Protection Board is considering this particular matter. They have not come to a clear conclusion yet, obviously, and we cannot be sure whether or not there will be anything further to be said from the European Data Protection Board before the 29th of March. If they do say something, if you've already clocked where this data flow is, you're in a good position to be able to act to apply that guidance. I wouldn't necessarily assume that they're going to direct people to put in place standard contractual clauses. I think my view is that it shouldn't be a restricted data transfer, and of course there have been and continue to be many businesses already outside the EU, businesses in the US, for example, who are processing data in the EU without any intervention from data protection authorities and in the absence of standard contractual clauses. So really, it's not the end of the world that these things don't exist, and hopefully the European Data Protection Board will provide some further clarity on this. But it's correct that there is no immediate action that can be taken to eliminate this risk. The best thing to do is to try to manage as best as we can as we go forward.
You mentioned the European Data Protection Board, and obviously the UK Information Commissioner's role in relation to EU regulatory cooperation and the Data Protection Board will change. Is it anticipated there continue to be any role for the UK ICO in a future EU regulatory framework?
Well, we hope so. The ICO is a key European regulator, and we believe they are probably the largest and the most well-resourced of all the data protection authorities across the EEA. We are well aware of the input they put into the work of the European Data Protection Board, the sheer volume and proportion of the output of the European Data Protection Board, where the ICO is a leading light, holding the pen on much of their guidance. And it would be a great loss, I think, to the European data protection regulatory environment and landscape if the ICO was not to be involved in the future. The focus of businesses, and rightly so at the current time, is mapping data flows and working out where standard contractual clauses need to be. But as we've already heard, the longer term issue is that businesses are going to have to comply with two regulatory regimes, the UK GDPR and the EU GDPR, and the consequence of that being that they will have to deal with multiple data protection authorities going ahead. This is a significant regulatory overhead, and it's not just something you have to deal with on the 29th of March, but it's potentially going forward indefinitely. So it is a priority for us to try to secure greater regulatory cooperation in the future. And I think that does mean a role for the ICO at the EDPB, and we will try to negotiate some kind of sensible way to manage this, to reduce the burden upon businesses, but maintaining the highest data protection standards in the future.
Thank you very much, Andrew. I know that there are still some questions coming through. Perhaps what we'll do is we'll just turn to our polling questions so we can put those out to the listeners. And then whilst they are responding to those, and we're waiting to crunch the numbers and come back with the aggregate responses, we can then be looking at perhaps a couple more questions whilst we're waiting for those results to come through. So I'll just run through what the polling questions are. Okay, so the first question: does your organisation's Brexit planning include personal data flows? And it's simply yes, A is yes, B is no, and C is not sure. So if you can answer away to that question, I'll move on to the second question shortly. Okay, the second question. Sorry, pull that up. Second question is: has your organisation prepared for a no-deal Brexit? So again, A would be yes, B is no, and C is not sure. And again, please let us know where you are with that. And then our third question: has your organisation decided on what its post-Brexit data flow solution will be to ensure data flows can lawfully continue? So again, A is yes, B is yes, based on the standard contractual clauses, and C is not yet decided. So whilst we're adding up the responses that we get back to those questions, I'll just turn to look at any questions that have just been coming through while we were just running through those polling questions, and whilst we were talking about the questions that had come in previously. So one question actually came in about appointment of representatives in the context of a group of companies. So, for example, a UK company has an affiliate in the EU, but they're two separate legal entities. Does the UK company need to appoint the affiliate as a representative or not?
So, well, you can have my view on that if you like. I think that if you have an affiliate, you are bound by the EU GDPR as a consequence of having that affiliate in the EU, and you do not need to appoint a representative. To me, under Article 27, you only need to appoint a representative if you have no branch or affiliate in the EU, but you are nonetheless trading goods and services with the EU or processing data of EU subjects. I think that the fact that you have an affiliate should require you to be compliant without appointing a representative. I see nodding.
I'd say it's the targeting of the services that's the key here, rather than the existence of an affiliate. Actually, I have another question here, which is we have a contract between a German controller. Some of these questions are quite technical. We have a contract between a German controller, a German processor, and a German processor, but we know that the server of the data processor are based in the UK. Do we have to sign the EU standard contractual clauses with the German entity? So the processor is based in Germany. So it's only a server that's in the UK.
There's presumably a UK controller here as well. They have a UK. The issue is that they must be bringing this data back to the UK. I assume. So if there's a UK controller, a German controller, and a German processor, there's clearly an international transfer between the UK and the EU, and for the continuing transfer back from Germany into the UK, I think there would be the need for contractual clauses. I'm not sure about this issue about where the servers lie. If there's a German processor, but the German processor is in fact processing in the UK.
Through a sub-processor, possibly.
I'm not sure where the processing is really going on there. You need to sort of work out, is that processor actually in the UK, or is that processor in Germany?
Yeah, I mean...
The ownership of the processor is probably a red herring.
There must be an entity in the UK. It's the role of that entity in relation to the processing. I mean, if it's sort of in a server farm, for example.
Yeah.
Or is it a UK instance of a cloud-based service provider? And I think perhaps, we may have to, whoever has sent that question in, if they want to provide us a bit more clarity about the context, we'll follow up. We'll follow up with a further, some more deeper thoughts after the webinar. In the meantime, I think we have the results back from the polling. So, in relation to the first question, does your organisation's Brexit planning include personal data flows? So, the majority of people say yes. 76.4% of respondents have said yes, the organisation's Brexit planning does include personal data flows. Now, moving on to question 2, has your organisation prepared for a no-deal Brexit? Again, a slightly smaller percentage, I think, but it's just over half have said yes. 58.6% have said that yes, they have prepared for a no-deal Brexit. Interestingly, it is nearly 30% who are not sure what the organisation is doing, and 12% who have said no, they haven't prepared for a no deal. And then the third question, has your organisation decided on what its post-Brexit data flow solution will be to ensure data flows can lawfully continue? Interesting, actually. It's quite a 46% of people have said yes, they're going to be basing their lawful data flows post-Brexit on the standard contractual clauses. 35.4% have yet to reach a decision on this question, which actually is interesting because obviously if you look at the question before in terms of steps that have been taken, obviously that suggests that this is perhaps out of that decision-taking around lawful data flows. And 18.5% have said that they have decided on what their data flows will be. So say there's about 35% who are still undecided about what to do post-Brexit. And with that, I think we've pretty much reached the end of our time today. So I just wanted to let you know that a recording of the webinar and the slides will shortly be available on our microsite, from which you'll be able to access also details of our forthcoming events and other webinars. So with that, it's just left me to thank Andrew for joining us today, to thank the other speakers for their contributions, and we hope that you can join us again soon. Thank you.